Legally Speaking with me, Tarun Nangia. Today we are delving into a topic for which maybe one show may not be enough. It could well go into many shows, which is exploring the interplay of PMLA, which is the Prevention of Money Laundering Act, Black Money Act, and tax statutes. And that is why, given the complexity and the interplay that we are going to discuss, this may require more shows, but we're making a good start. I have a stellar panel with me. We are very happy that we have Justice Talwant Singh joining us, who, as we all know, is a senior advocate who practices at the Supreme Court and other courts across the country. Senior Advocate Percival Bilimoria joins us. He practices at the Supreme Court of India, Delhi High Court, and other forums. Advocate Aditya Ajgaonkar joins us from the city of Mumbai. He's also written on this subject extensively. So, quickly delving into the topic, Aditya, you've done some research on this. Could you give me a basic brief and then we delve into the opening comments about what did you research about this?
Sure. Ever since PMLA became a hot topic in the last few years, a lot of questions were raised about the interplay. And the Supreme Court has answered a lot of questions, in fact. And it is fascinating, because PMLA has an entire schedule. And, it doesn't necessarily stand on its own legs, but it needs other scheduled offenses to exist. There is an interplay with a whole variety of acts, right? We are today looking at income tax, we're looking at Black Money Act, maybe GST. And if you actually look at the undercurrent of the PMLA, it is extremely broad-based. The schedule comprises of a lot of acts, regular offenses, IPC offenses. In fact, there are recently, I did not know whether this was, whether I would see any prosecution for this, but even for copyright infringement, there are, that also finds way in the schedule. Now, the Income Tax Act, all of us are fairly aware of. A lot of us pay income tax every year. The Black Money Act is very interesting because I don't really know why it's called the Black Money Act. There is no, black money is not defined in the act at all. What it actually is essentially is a taxing statute for foreign assets that are undisclosed and foreign incomes that are undisclosed. So I do not know whether Black Money Act, the name is a misnomer or not. But interestingly, Black Money Act, amongst Income Tax Act, GST, and Black Money Act is the only one that is actually scheduled to the PMLA. And that means that there is a direct live nexus between the Black Money Act and the PMLA, which makes it very, very interesting. Because there were issues whether income tax proceedings, whether GST proceedings can actually trigger PMLA. And the Supreme Court has shed some light on it, but I don't think the story is over yet. And I would love to hear what my seniors have to say on this topic.
Point well taken. I go to Senior Advocate Percival Bilimoria, as they joke that you are a chartered accountant in your past life, but it's so true that you qualified in chartered accountancy and hence you have a lot of interest in these subjects. Could you give me your opening comment on the interplay between these three laws, which is PMLA, Black Money Act?
So it's pretty simple. There was as you know, a decision to review PMLA, the Vijay Madan Lal decision, and I think it's a very highly criticized decision sometimes, but I don't know why. This Vijay Madan Lal has already clarified that there could be situations where you have a tax issue, a contravention of a taxation law. And it says that we will construe the meaning of proceeds of crime very strictly. And it clearly lays down the proposition that if there is some statute which is not in the schedule to the PMLA, because proceeds of crime pertains to criminal activities relating to scheduled offense. Now, there's something not in the schedule, and as Aditya just pointed out, one of the main laws there is the Black Money Act. But if it is not in the schedule, then it may be an offense under that particular tax law, but it cannot be an offense under PMLA. So that proposition is very clearly laid out. Even reading the plain letter of the law, that would be the position. Now, the thing is that Black Money Act is different from income tax. So income tax is not in the schedule, but the Black Money Act is. Now, Black Money Act only pertains to assets or income abroad. undisclosed assets, undisclosed income, which is outside India. So that's essentially the lay of the land. You also have some provisions of Customs Act, evasion of customs duty, and fraudulent documents that are presented. So there are certain provisions of the Customs Act which are also in the schedule. If it's not in the schedule, you have to proceed under the tax law, but you cannot proceed under PMLA.
Okay. Point very well taken. Now on this topic, I'll take an opening comment from Justice Talwant Singh. Over to you, sir, for analyzing what the two councils have spoken and also your analysis of this interplay between these three laws.
Yeah, basically, when I was on the bench, especially in district courts, these PMLA offenses, they used to take a back seat. So I remember the days when in CBI cases, after the charge sheet is filed, we used to have a visit from the PMLA officials. They'll come, they'll request for a charge sheet. CBI would generally oppose, but we were kind enough to hand over a copy of the charge sheet. And they used to prepare their so-called, now it's a complaint, even now it's a complaint, on the basis of the charge sheet, the case which has been already investigated. But in the recent years, let us say in the last 1 decade, now the situation is otherwise. It's the PMLA authorities, the ED authorities, which are taking the lead. And PMLA is all pervasive. As Mr. Prajul Bilamore has pointed out, that although tax laws have been kept outside its ambit, but it tries to sweep everything on the basis of the proceeds of crime. Although one has to strictly construe the schedule. The schedule also is black money, as Mr. Aditya has pointed out. It's a misnomer, or I think I've just gone to the definition. There is no definition of black money given in the Black Money Act itself. So I think if they remove this opening word black money, even then I think the name of the act is quite complete. It will call rather the Undisclosed Foreign Income and Assets and Imposition of Tax Act 2015. I think which is the intent behind the act. But just to make the name a bit attractive, I think the framers of the law thought that we must put emphasis on the black money. This is part of the schedule. Of course, there is a direct interplay between the two. Once we talk about black money or talk about the undisclosed foreign income and asset, the Income Tax Acts, not directly but indirectly sets in. So that is the present situation.
Point very well taken. I'll move to a bit of specific questions. Aditya, if you could sort of speak on how tax evasion A, B, misreporting under the GST or the IT Act lead to an investigation under PMLA. Does it happen more often, or doesn't it happen?
So the PMLA, we tend to, as lawyers, see the litigation aspect of it. But for this question, what is important is that the investigative framework also includes intelligence sharing within agencies, right, between GST and income tax. We keep focusing on the MLA when it comes to PMLA. That's my standard joke. The P is prevention. So they're not only trying to punish those who are indulging in proceeds of crime, but also to avoid money laundering as an offense itself. So there is a very robust framework for sharing of intelligence. So, one aspect, of course, is that, if there is a search and seizure under, say, Income Tax Act on GST Act, it may not directly trigger off proceeds of crime with respect to it being in the scheduled offense. It per se being a scheduled offense that you have evaded tax. But if there are forged documents found, forged public documents found, these are all independent offenses separately. These could be offenses under IPC. And those offenses very often find their way in the PMLA schedule. So we cannot say that, they per se are different. Another aspect is, especially with respect to income tax and GST, whatever is found out during, assessment, summary procedure, all this can be analyzed by different agencies now. Now there is FIU IND, the Financial Intelligence Unit IND, is a specific intelligence gathering agency to make sure that financial intelligence is shared within agencies. And, in fact, the GST network, there was GST brought under PMLA was, a headline in the newspaper a while back. What they did was put the GST network within the intelligence sharing apparatus under the PMLA. So these aspects are there. Another aspect is, of course, that evasion of tax is a very specific offense under black money that finds its way under PMLA. But I would not rule out very specifically income tax action or GST intelligence action not attracting PMLA proceedings. And if you were to give me, a little bit of rope, Pavana Dipur is a very commonly cited judgment under PMLA. And a very interesting facet came out under that because in the schedule, there was, common intention is also scheduled. Not 34, I think it was, I forget the section, but the common, the conspiracy to commit a crime is also scheduled under PMLA. And it was often thought that because that is scheduled, if there is a conspiracy to commit, common intention to commit income tax offenses, that also
120B.
120B. Thank you, sir.
IPC, I would rather say.
Yes.
I do not know whether they have come up with a new schedule where IPC is replaced by.
No, they have not yet. They have not yet. But
what will happen to the new offences which are taking place now after July 2024?
So there is a section that says equivalent law. And I believe that is now being pressed into service right now. Equivalent law. But they should really update the IPS schedule. But what happens is because common intention was there and it was scheduled, if there is a common intention between 5 people to have an income tax evasion of tax, conspiracy, whether that could be done or not. So Pavana Dibur clarifies, I don't know whether I pronounced it correctly, that it is not enough only for 120B to be invoked for PMLA proceedings. Other scheduled offense must also find its way for PMLA proceedings to come up. So the interplay is fairly complex.
Point very well taken. I'll take this to Senior Advocate Percival Bilimoria. I also want him to answer one more question, that can one single transaction be subject to multiple penalties?
So, okay. So before I answer it, let me just clarify, as Aditya, very aptly put it. When you have, as I said earlier, scheduled offense, that's the key. Criminal activity pertaining to an offense which is scheduled. Now, in the schedule, I think the very first item is criminal conspiracy. What that means is that, if you look at it one way, even petty theft can be a PMLA offense. But I think, the courts have now clarified that you can't just have 120B as a standalone offense. It is 120B and, obviously pertaining to or in relation to another scheduled offense. It's only the intention of the legislature is to cover only scheduled offenses. And by including 120B, what it intends to do is either scheduled offenses or conspirators to scheduled offenses. So I think that's the correct principle. It's already been set out by the law. Of course, when you read the fine print, you could always find some way of still trying to levy charges or whatever. But now to come to your point, so you see, these are separate issues altogether. So you could have a situation, if it is a scheduled offense, you will have PMLA, but you'll also be hit by the normal tax provision. So for example, in income tax, you have income escaping assessment, right? So if there is undisclosed income, now Income Tax Act by itself is not a scheduled law, but there could be situations where you may still be roped in to PMLA, but definitely you would be taxed. But I think that is where, as I pointed out earlier, the paragraph in Vijay Madan Lal, which is supposed to have reviewed the law, comes to your help, because it very clearly says that you have to interpret that section very strictly.
Point very well taken. I'll get Justice Talwant Singh in for analyzing the two answers made by Senior Advocate Mr. Bilimoria and Advocate Aditya Ajgaonkar.
Yeah, as if we see 120B, I think all the panelists agree that this itself cannot be a stand-alone offense. Because even in normal parlance, let us forget about the PMLA for the time being. Even in normal parlance, there has to be another offense for which this conspiracy was hedged. If that offense itself is not covered in the scheduled offense, then I think PMLA cannot be invoked, and of course we'll wait for the judgment. Second thing, if 120B itself is to be considered as an offense, and what my own understanding is, suppose there is one person who has committed the scheduled offense, but there are other persons who are, although they are not directly a party to the scheduled offense, but they have conspired with this man for committing the scheduled offense, they can be roped in with the help of 120B IPC. This must be the reason for putting it as a very first opening line in the schedule. Of course, as we have discussed, that the government has to, have a relook, not in view of the judgment, even in view of the change in circumstance, because IPC is no longer there. So we do not know which of these scheduled offences are still offences under BNS or not. So if they are, of course, you have to put the relevant clauses, and for the offences that have taken place up to June 2024, of course, IPC will prevail. The taxation laws which are there, of course, directly, as I already said, that directly, since they are not part of the schedule, it can be argued that you can't directly have the implication of PMLA coming there, and there are stringent penalties provided in all the taxation laws. I think the government is very strict, even the courts are very strict, and it's not easy to come out once you have committed one of those offences. So let us see, I think, but what I feel, sooner or later, the way the things are going, we will have all these tax evasion crimes also part of the schedule. The day is not far. This is what I can safely predict.
Point very well taken. I'll just get this question in that, is there any threshold for a tax violation to be considered as a predicate offense under PMLA, Aditya?
No, there isn't any threshold because, again, tax offenses are not scheduled under the PMLA. So there's no question of threshold being there for a tax violation to be under PMLA. Unless, of course, we're looking at customs, then that is a whole different. But with respect to income tax and GST, they are not. But again, as we said, forged documents, etc., which can also be, offenses under IPC, etc., because these special acts have prosecution sections, but they do not preclude simultaneous proceedings before the special court, even under regular law. So, it all depends upon how the complaint is made by the income tax authorities or the GST authorities. And, that itself is a whole different ballgame, because what really happens is, suppose, let's take the case of fake invoices. It is a very common scam, that is a bogus purchase. If you look up tax judgments, you'll see bogus purchase. Now, that means obviously there are fraudulent invoices that have been made. So there will be action under Income Tax Act. There will be action under GST Act. There will be penalty under Income Tax Act. There will be penalty under GST Act. There could be an offshoot prosecution under IPC. Now, penalties, etc., and prosecution under Income Tax and GST per se will not attract PMLA. But if sections of IPC is also taken up, then of course PMLA can be invoked. That would also depend upon the quantum of crime, because GST does distinguish, gives graded punishment based on the quantum of the offense.
Point very well taken. But I'll go to Senior Advocate Percival Bilimoria. Do you see, Mr. Bilimoria, what defense does a businessman or a business have when they face a simultaneous prosecution between, say, GST, income tax, Black Money Act, and PMLA? Also, do we also dump all the documents to a single agency and it is shared by all of them, or you have to submit to each agency different documents asked at different times? Secondly, do these agencies pull out documents on their own, or you are required to submit?
See, in income tax, it is fairly common. Suppose somebody has been raided and the tax department has some documents with them. It is fairly common for them to share those. It depends on agency to agency, however. But income tax, I can tell you, yes, it's quite liable to be shared. I think the answer your first question, the best defense is, just keep on the straight and narrow and hire a good lawyer. That is no other way. Because, see, these are all fairly draconian laws, right? And, why would you want to get into any trouble under any of this legislation?
Okay. Point very well taken. I see Justice Talwant Singh smiling. We'll get him in. What do you, sir?
Yeah. So we all exist because people violate laws. Otherwise, there is no freedom. Judges, lawyers, or the courts. So people try to find ways. And I was just going through the scheduled offences under IPC. I think because cheating is covered and the counterfeiting, a government seal is covered. So naturally, even if in GST you're trying to violate the GST law, let us say the input credit, naturally you will be making a forced stamp of the GST officer or something. So what these agencies do when they file complaints or the charge sheet, whatever way you look at it, they, apart from invoking the relevant clauses of the taxation laws, they also invoke IPC. And now, of course, the new laws. Okay. So once in the same charge sheet or in the same complaint, they have invoked the relevant taxation laws and they have also invoked IPC. IPC's offences which are mentioned there in the complaint or charge sheet, if they are covered under schedule, of course, PMLA can be invoked. So I think वो कहते हैं ना कान सीधा नहीं पकड़ा तो घुमा के पकड़ा है. That is the difference. Okay, so instead of directly having and those offences under the schedule, as soon as you invoke IPC related to any offence related to documents, securities, cheating, counterfeiting, and I think once you try to avoid tax, maybe it's income tax, direct taxes or indirect taxes, you are committing one of these offences. So indirectly you will be covered. Yeah.
Point very well taken. I think the next show that we do, we'll discuss some specific cases from across the country, maybe 2 or 3 of them, to get an understanding of how courts are adjudicating or looking at these matters and what kind of violations happen. But I would like to thank Justice Talwant Singh, Senior Advocate Percival Bilimoria, Advocate Aditya Ajgaonkar. This is an interesting discussion with varied opinions. And we do a follow-up on this with specific cases. Would request your time then, but appreciate your joining us. Thank you so very much.
Thank you so much.